Have you ever heard of a legal horror story where someone lost their home in a divorce due to a costly mistake? Maybe you've heard some common legal misconceptions, such as the mother always gets custody, or even you don't need a lawyer if the two of you agree on everything. These misconceptions can be costly. They can cost you your assets, they could cost you your rights, they could even cost you time with your children. In today's video, we're going to uncover shocking legal horror stories, debunk some common legal misconceptions, and go over what judges are really looking for and paying attention to in family law cases. So first, let's go into those shocking legal horror stories. The first legal horror story that we'll be talking about today is a parent who lost custody of their child due to social media posts. I had a mother who was a previous client of mine, and she came into court with a 50-50 custody arrangement, and she was trying to reduce the time that her ex-boyfriend had with their child. The issue was, she posted constantly on social media. She posted continuous negative posts about her ex-boyfriend. She had negative posts about the guardian ad litem. She even had some negative posts about the judge. The issue was, all of this got brought to the judge's attention at the court hearing. And all of those posts can get used against you to show that you're not willing to foster a positive co-parenting dynamic with your parent, which is something that is super important to any judge evaluating your case. And because this judge, probably rightfully, believed that the mother wasn't going to foster a positive co-parenting relationship, mother lost 50-50 custody, and instead, father ended up with primary physical custody, and her visitation was reduced to every other weekend. The lesson to learn from this: never, ever post about your case on social media. I promise you, your ex's attorney is looking through your posts to see if you have any posts like the ones that I've described. The second legal horror story that we'll talk about today is the do-it-yourself divorce. Picture this. You and your spouse are amicable. You're getting along. You agree on everything. And I mean pretty much everything. So the two of you come together and you decide, hey, we don't want to go through the expenses of a lawyer. Let's do it ourselves. Let's go online, use one of those online forms to draft a separation agreement. Surely nothing can go wrong there. Wrong. Absolutely wrong, and it's not something that you should do. I had a wife who came to me once. She was in that same predicament. Her and her husband, they agreed on everything. They were getting along great. They decided to save some money. They were going to go online and draft a separation agreement. She had agreed to waive spousal support, but the idea behind that was that she was going to be able to go after his military retirement when he eventually retired. The issue was, neither of them understood the language that online form put in their agreement. Because of that, she ended up signing an agreement which made it so not only did she waive the spousal support, but she ended up waiving the military retirement too. And there was language in that agreement generated by the online form that said she could never go after that retirement in the future. Wife ended up spending thousands and thousands of dollars in legal fees because she now had to invalidate this agreement in order to get that military retirement. But the issue was, the court sided against her. So she lost alimony and she lost the military retirement. Oh. The lesson to learn from this is trying to save money in the short term can significantly cost you in the long run. Do not sign any agreement without at least having an attorney look it over. The last horror story that we're going to talk about today is the prenup that went wrong. There was a husband. He came in. He had a different law firm draft his prenuptial agreement. He thought he was protected. He thought he was set. He was to get the house and the divorce. Wife wasn't going to be able to touch his retirement. Wife wasn't going to be able to have any spousal support. He thought he was good. The issue was his prior attorney didn't draft the prenuptial agreement correctly. And because of that, wife was able to successfully challenge the prenuptial agreement, and the court invalidated it. The agreement went away because it wasn't properly drafted. Husband ended up having to sell his home, lost a portion of his retirement, and ended up having to pay his wife $1,000 each month in spousal support for 10 years. All because this prenuptial agreement wasn't drafted correctly. An ironclad agreement is important, and you need legal representation to properly draft this agreement to protect yourself in the future. So now that we've talked about some of these legal horror stories, it's important to know why they happen. And they often happen because of 3 common misconceptions that people have about family law. The first common misconception is that mothers always get custody. This is just not true. The court looks at what is in the best interests of the child, not gender. If you're a father and you can show up to court and you can show that you provide a stable and loving environment for your child, the court absolutely would consider awarding you 50-50 custody, if not primary physical. And if you're a mother, you shouldn't get too comfortable and think that you will automatically get custody. You have to demonstrate those same things. Secondly, there's a common misconception that verbal agreements are binding in custody cases. This is just not true. A verbal agreement will never hold up in court. It's not binding. It's not an effective agreement. Either of you would be able to backtrack on that agreement at any point in time, and the judge would allow you to do so. In order for it to be enforceable, it has to be in writing, and you have to have presented it to the judge to get it to be in a court order. And the last common legal misconception is that if the 2 of you agree on everything, you don't need a lawyer. Even if the 2 of you are agreeing now, you still want to involve a lawyer in the process to make sure that you have an ironclad written agreement to prevent future disputes and to make sure that your agreement gets enforced in the future. Believing these misconceptions can put your family, finances, and future at risk. Make sure you have all the information before you make any decision. And speaking of knowing all the information before you make a decision, it's important to know what judges are looking at in different family law cases, because ultimately, judges look at the same key factors for every case. For example, in a custody case, the court is looking at what's in the child's best interest. Which parent is providing a stable household? Which parent is prioritizing co-parenting effectively? In a divorce, the judge is going to look at financial transparency. Has there been a full and accurate disclosure of all financial information? And if the parties have reached an agreement, is that agreement fair and equitable? And lastly, in any family law case, the judge is going to look at your conduct. What I mean by that is the judge is going to look at your social media posts. The judge is going to look at the communications between yourself and the other party. The judge is even going to look at how you act in the courtroom. What's your demeanor? How are you responding to questions? The judge is going to use all of this information to inform their perception of you as an individual and as a parent. And they will use this information to come to a decision. And knowing what a judge is looking for can help you avoid costly mistakes and help strengthen your case. So now that we have discussed some common legal pitfalls, let's talk about some ways that we can prevent these legal mistakes. The first way is by hiring the right attorney. Avoid attorneys who don't specialize in family law. They will not have the experience, time, or ability to focus on the details that truly matter to help win your case. Also avoid attorneys who don't return your calls or emails. And lastly, you want to make sure that any attorney you go with has a transparent fee arrangement for payments and that they're not hitting you continuously with hidden legal fees. Secondly, you want to put everything in writing. As we've previously said in this video, a verbal agreement is not binding. It's not enforceable. Any agreement that you come to with your ex needs to be in writing and submitted to the court as a court order to make sure that it is valid, to make sure that it is enforceable, and also just to keep track of what the agreement actually was. The last way to avoid costly mistakes is to never post about your case on social media. Never, ever, ever talk about your case on social media. It can and will be used against you in court. There is no positive to doing it. Legal mistakes can be devastating, but you don't have to do this alone. My name is Julia Steitley, and I'm a litigation attorney at Malone Hatley PC. Our experienced attorneys are here to help you, whether you have a divorce case, a custody dispute, or even need some estate planning advice. Don't delay. Schedule a consultation today. We're here to be your partner throughout this process and to help you navigate its challenges, leaving you in the most confident position about your case.